Okay, this is going to be part two of acts, regulations, and rules, etc. What's the difference and why does it matter? The answer to that is only by understanding these issues can you understand how you're being brainwashed in investigation reports. So before you look at this video, make sure you look at part one, because again, my videos build on themselves, on one another, and you have to have, the previous videos in order to understand what's coming up. So make sure you look at part one before going through part two. So again, before we get into this video, I would like you to like, share, subscribe, and make sure that you're still subscribed if you have subscribed in the past, because the likelihood of people getting unsubscribed, in my opinion, is very high because there are just so many parties that don't want this information to get out to the many rail families that need to understand these issues. Okay, now on this page, I'm showing you something very interesting that I found. Um, and it is very interesting. On the left-hand side, and both of these are the same document. On the left-hand side, you can see rules respecting minimum qualification standards for railway employees. And again, same title on the right as you see on the left. Okay, on the left, this is what I believe to be the original document. It's also known again as TCO 0-102. This is the document, in both versions of it here. It's the document that resulted from that Railway Safety Act, Section 19 order, which was issued by John Baird after the Mac Yard incident, when he said, I want you to do a rule which will replace the regulation. So this is the document that was created by the Railway Association of Canada. And you can see here, I blacked out the logos for the Railway Association of Canada, but you can see the writing. The Railway Association of Canada under the blue here for the document on the left, and you can see it at the very bottom of the page, the Railway Association of Canada. It's the same document, but from two different sources. The one on the left is taken from the Teamsters Canada Rail Conference website. That is the rail union that represents most rail workers in Canada. And so that's the document they had on their website. And this document was, you can see here, the second arrow here on the left at the bottom says approved June 23rd of 2009. So the union is led to believe that this document was approved. And so there's a whole issue with that, because the two documents, the only thing that is truly different between these two documents is the cover page. The document itself, the text behind these two cover page, the text is identical, okay? The only difference between these two documents is the cover page. And you'll note RailCan is the source for the document on the right. That is the Railway Association of Canada website and the version they had on their website. Now, this one, if you can see the second arrow at the top, says updated 2017, in May of 2017. So the only update is the cover page. The text behind the cover pages is identical, word for word. So what was changed on the cover page? Well, the picture was changed, okay, as far as what the cover page looks like. But note here, the very key difference on the cover page, and the only difference, as the document text is identical for both on all other pages. Note this second arrow on the bottom here, on the bottom right, on the version that is found on the Railway Association of Canada website, where now it added, instead of saying approved on June 23rd, 2009, the June 23rd, 2009 now has a little asterisk next to it for the Railway Association of Canada version of the document. And that little asterisk is the second arrow below. It says this rule is not in effect until the regulation is repealed or revoked. I'm sorry, it says revoked. So again, this rule could not go into effect until the regulation was repealed. But the version on the union website showed that this was approved. So the first question I would have is, was the new cover page also provided to the union? If not, why not? Because the union version makes it look like this document was approved and would be in effect. And folks, this document is a complete public scam. And the stuff in that document would be stuff that the union would absolutely be wanting to fight. And we're going to go over this entire document that I called the public scam. Because there's no way that a union, to me, would be okay with what's in this document that resulted from the Railway Safety Act Section 19 order pertaining to the Mac Yard incident. So I guess the big issue there is if you're a union, okay, and a lot of these people that become union leaders, they start out as, the conductors, locomotive engineers. They work their way up into the ranks, become a union rep, and then they come into and lead the union for the members. They're not necessarily lawyers and whatever as you would have at the Railway Association of Canada, which is comprised of, rail executives, many of them which can be actual lawyers for the rail carriers. And so the people on the right, in my opinion, would be, very, very aware of their brainwashing efforts, in my opinion, and what the implications of rules versus regulations, approved versus not in effect until the regulation is revoked, and all of that. So the people on the right absolutely know what the implications are of every single word in this document. Is that true for the people on the left? Maybe not. But the way the people on the right at the Railway Association of Canada or Transport Canada can protect themselves if anything ever goes to court or is disputed is, well, ignorance of the law is no defense in court. And so they know that at the Railway Association of Canada, the people who put together the rules respecting minimal qualification standards for railway employees, which was supposed to replace the Railway Employee Qualification Standards regulation. And so when there's funny stuff going on, these people on the right at the Railway Association of Canada and at the Ministry of Transportation absolutely know the hierarchy of acts, regulations, rules, standards, guidelines, etc., and the legal implications for that. Whether or not that's true for union leaders, I don't think so. In my opinion, again, these are people that work their way up through the ranks, and they're likely not lawyers. So if you're a rail union employee or representative and you see approved and that's all you see, okay, so it's approved, so that would mean to a union it's in force, that this is now the law, because that key update to the cover page, which we see on the right, is missing, that this doesn't go into effect until the regulation is revoked or repealed. So was that new cover page ever provided to the rail unions? And again, if not, why not? Because the rail unions would absolutely be looking at what's behind the scenes, what's behind this document, these new rules. And they would likely be spinning their wheels, in my opinion, and wasting their time trying to fight what's in this new supposed proposed rules. Whenever there's contract negotiations and whatever, they have to argue and try and, fight for their union members. Well, if you're thinking something's already approved, you're going to be spinning your wheels fighting for something that's not even in effect. So it's a total waste of the union's time is what I'm trying to get at here. And so that's a key question, I guess, for lawyers. Was the updated cover page provided to the union? And if not, why not? And there's a lot of other issues here. If you look at the date of the update, that was in 2017. Well, okay, I started to blow the whistle on fake qualifications in the rail industry in 2016, around June 2016. So you have to wonder, how come this was updated with this nice little sentence here on the front um, in 2017? Is that because Transport Canada and the railway would have made the Railway Association of Canada go make that change on that document? And was the union ever given a revised copy, or is the union just expected to spin its wheels, fighting for things or against things that aren't even in effect? A total waste of the union's time. So, huge issue. Okay, now this is just a slide showing you that John Baird, who was Minister of Transportation when the Mackyard incident happened, he's the one who issued that Section 19 safety action taken to water down the regulations there to protect frontline rail workers and rail families, rail investors, and the public at large. Well, John Baird would, in 2015, when he left the government of Canada, he went to the board of CP Rail, which is now CPKC, and he's there to this day, impacting the lives of frontline rail workers in both Canada and the US, as well as the lives of all residents and citizens in both Canada and the US. So, I just have to laugh when I see, okay, this guy, look at the bottom here, how, we talk about social responsibility committee, and he's a member of the risk and sustainability committee. Okay, well, in my opinion, social responsibility, given what we've seen of the actions of John Baird when he was Minister of Transportation, trying to help rail carriers water down critical regulations pertaining to the proper training of frontline rail workers. You just have to laugh when you see this stuff because you'd be crying. It's just that bad. Okay, so these two pages are just to show you where I got the information that, regulations can be made by agencies such as the Canadian Transportation Agency, which can include rail executives. They can be made by the Railway Association of Canada, as it represents or acts as an agent for all of its members. And again, they represent 50 to 60 railway companies, including all the Class 1 rail carriers operating in both Canada and the US. And so they have the right to make regulations or rules pertaining to the training of those persons in the rail industry, and also in matters pertaining to the licensing of those persons. Now, I also provided this section to show you at the very bottom here, the paragraph where it says regulations override rules. So if there's any inconsistencies in rules approved in relation to a particular company by the minister under section 19 or 20 in respect of that matter, those rules are at that time revoked to the extent of the inconsistencies. So that's important, again, when you get to things like the definition of a yard or a transfer, because if the new rules have a new regulation, have a new provision in them, a change in definitions or anything that contradicts an existing regulation or something that's higher up in the hierarchy of acts and regulations versus rules, guidelines, standards, whatever, the higher authority overrides and prevails and makes the lower inconsistent or, contradictory information or new rules or whatever, null and void. The higher authority will always override. Okay, and this, folks, is again another copy of the Railway Safety Act, pages 24 and 25, which has to do with rules. And note here on formulation or revision of rules, this is not regulations. They're talking about rules here. It says the minister may order or require a company to formulate rules respecting any matter referred to, okay, in the subsection which had to do with, for example, employee training programs, as I explained on the previous slide, and to revise its rules respecting that matter, and within a specified period of time to file the formulated or revised rules with the minister for approval. So this clearly shows in the Railway Safety Act that rules must be approved by the minister before they go into effect. That's not just the case for regulations. It also applies to rules. And that, again, in the second part here, a company has a duty to consult with like the unions and whatever before those rules are filed. So this section, this thing about the minister may by order require a company to do so, that is exactly what was done in the when the fake qualifications surfaced in the 2007 Mackyard incident, which is the rail yard outside of Toronto, where John Baird again issued that Railway Safety Act Section 19 order. And that was provided on pages 25 to 31 of that railway investigation report, telling all rail carriers to overhaul all frontline rail worker training programs as a safety action taken. But this, in my opinion, was just a complete and total public scam. And you're going to see why as we actually look at the document that was formulated and approved by the Governor and Council in June of 2009. And again, those were new rules that were supposed to replace regulation SOR 87-150, the Railway Employee Qualification Standards Regulation, with Transport Canada literally ordering the watering down of the laws there to protect frontline rail workers and the general public. Why did Minister Baird not ask for new regulations? He had the right to tell them to write up a new regulation, but he didn't do that. I mean, we have seen that, agencies, that regulations, according to that document on the creation of acts and regulations and whatever, that it grants the power, the Minister of Transportation can grant the power to agencies to write up regulations. And so when wanting to revise SOR 87-150 and training programs for railway employees, why did John Baird not ask for a new regulation enforceable in court? Why did he decide to try to water this down with rules that are not enforceable in court? Huge issue in my humble opinion. So the new proposed rules, also known as TCO 0-102, did, however, again, provide a nice document from which investigation reports at the Transportation Safety Board, such as those pertaining to the death of conductor trainee Jason Clooney, well, those new proposed rules provided a nice document from which a sentence here and there could be pulled to put into other investigation reports, even death investigation reports. And that's how you get into the whole thing of brainwashing, how they are allowed, they can do it via the playing of these games behind the scenes. So there's going to be a lot more on that in the brainwashing of rail families and taxpayers videos that I'll be doing on that subject. Okay, so again, the key point on the left here, we have the Railway Safety Act, Section 19, which overrides the Railway Employee Qualification Standards Regulation, known as SOR 87-150, also Section 19. Folks, that's another part for how they can create the confusion, because people will remember, oh, this is Section 19, that's Section 19, but they may not pick up that there's a switcheroo going on when issues are discussed in a railway investigation report, that Section 19 is being ignored as far as the Act, and it's being replaced by Section 19, the regulation, which is overridden by the Act. So if you look here, the Act, in the case of conductor trainee Jason Clooney, in his report, the Railway Safety Act, Section 19, which clearly says that changes to training programs and rules must be approved by the minister, that is ignored in the Railway Investigation Report pertaining to the death of conductor trainee Jason Clooney, which is R13W0260 is the number for that report. Instead, we're only given in that report what is on the right here, which is the regulation, which is lower than the Act. And the regulation only states a railway company shall establish employee training programs for each occupational category. A rail company shall establish and modify its employee training programs in consultation with the trade unions representing its employees in the occupational categories. Then, instead of saying it has to be approved by the minister, it just says in the regulation, within 90 days after the coming into force of these regulations, a railway company shall, with the committee description, shall provide a description of all employee training programs relating to each occupational category, and within 90 days after any changes made to an employee training program require, by subsection 1 above, a railway company shall file with the committee a description of the change. So the very, very key one here is point number 4. Within 90 days after any change is made to an employee training program required by this subsection, the railway company shall file with the committee a description of the change. Nowhere in this regulation are we told that all of this needs to be, any changes to training programs must first be approved per the Railway Safety Act, which overrides a regulation that changes to training programs must first be approved by the Minister of Transportation. That is not in the regulation part. And again, the Act is totally ignored in Jason's accident report pertaining to his death. All we're given is this: within 90 days of any change made, that the rail carrier has a responsibility to provide their change to basically Transport Canada. So it's an after the fact thing. It's after you've done the change, then you need to tell us about it. Whereas the Act says, no, those changes must first be approved by the minister before you can implement them in the field. And that, folks, is a huge difference. Okay, so John Baird had been a politician since at least 1995, and he was the one who, because of the Mackyard incident outside of Toronto in 2007, he was the one who took that safety action taken in the report R07T0270, where he issued an order. So he ordered all federally regulated railway companies to develop a rule, not a regulation. He could have asked for a regulation, but he didn't do that. He asked them to come up with a rule to update and replace CTC 1987-3 rail, which is also known as SOR 87-150, the Railway Employee Qualification Standards Regulation. Now, CTC 1987-3 rail, if you look on the left-hand side here, this is again the copy that I was given via access to information of the Canada Gazette, which is the official publication of the Government of Canada. When a new law comes into effect, it has to be published in the Canada Gazette. So where you get this CTC 1987-3 rail, if you look at the first top left, the big arrow here, that says the Canadian Transport Commission. So that's where you get CTC, the Canadian Transport Commission. And all of these were regulations or new laws pertaining to the rail industry that had been published in March of 1987. So that's where you get the 1987-3 rail. 3 is the third month, the month of March. 1987 was the year the law came into effect. So that's where you get to replace CTC 1987-3 rail, which was called, again, per John Baird, the Railway Employee Qualification Standards Regulation, which, if you look at the bottom of the Canada Gazette here, those three arrows at the bottom clearly show the Railway Employee Qualification Standards Regulation is the name of the regulation. The next arrow at the bottom, the middle arrow, shows SOR 87-150, which was the number of the law. And then it shows the month in which it came into effect was March of 1987. So that's just to tell you, CTC 1987-3 rail is the same law as SOR 87-150, the Railway Employee Qualification Standards Regulation. It's a regulation enforceable in court. So what we had here is John Baird, the Minister of Transportation at the time, asking basically all federal railway companies federally regulated in Canada, and that again includes all rail companies operating in Canada, so that includes the U.S. rail carriers also, the Class 1 carriers that are U.S. companies. So they were all represented by the Railway Administration. The Railway Association of Canada is the agency that took all of that input from the rail carriers, which are their members, put it together and came up with the new rules respecting minimum qualification standards for railway employee, a new rule known as TCO, and then it was 0-102 was the number for that new rule, which again never went into effect because the old regulation, which is SOR 87-150, was never repealed. But John Baird, the point here is that John Baird was a politician since 1995, first with the legislature of Ontario for quite a while, and then he went to work under the Prime Minister Harper's administration, and he had several roles there. One of them was Minister of Transportation. So as a politician, a career politician, he absolutely knew what he was doing in 2007 when he issued this Railway Safety Act Section 19 order to supposedly overhaul all rail programs and change a regulation to a rule. He knew exactly what he was doing when he issued that order to replace a regulation enforceable in court with rules which would not be. So again, folks, on the left-hand column here is the Section 19 of the Railway Safety Act. But now, if you look on the right-hand column, you can see here with the very small, the shorter, thick arrow at the top shows that this is page 9 of the Railway Investigation Report pertaining to the death of conductor trainee Jason Clooney. And what we're provided there is not Section 19 of the Railway Safety Act. What we're provided there is Section 19 of the regulation, SOR 87-150, the Railway Employee Qualification Standards Regulation, which only says that changes must be filed after the fact with Transport Canada. It doesn't tell you that those changes must first be approved according to the Act by the Minister of Transportation. It just gives you the illusion that the only responsibility of the rail carrier when there's a change to a training program is to file that change and a description of the change with Transport Canada. So again, the Act overrides the regulation. And so what's happening here in Jason's accident report is, on the previous pages, we talk about, rules that aren't even into effect, and we're going to go through all the brainwashing stuff. I'll show you it all more altogether by going through those 4 or 5 pages consecutively in the brainwashing video. But, that's how they're setting people up for their brainwashing. We talk about rules that aren't even into effect. Then we go into regulations when we should be talking about acts as the proper authority and what should have happened. And so this is, quite frankly, folks, the Transportation Safety Board says that it's impartial and that they just provide the facts and they don't take one side or another. They just provide the facts. But you can clearly see that by, not providing the real facts, that the Railway Safety Act says those changes must be approved before implementation, and just providing us a regulation that says they need to file their changes with Transport Canada within 90 days after any changes made to the employee training program. There's a big difference there, right? So you provide only the regulation, you ignore the act, which overrides the regulation and which requires your changes to first be approved. So they make it look like, oh, look, this is the law, this is the regulation. And so we're following the regulation. And, the Transportation Safety Board, by just providing this and not providing the Railway Safety Act Section 19 that talks about approval by the minister for any changes prior to implementation, well, is the Transportation Safety Board really being impartial? Or are they being very much on the side of the rail carrier and trying to protect the rail carrier here in a railway investigation report pertaining to the death of a conductor trainee? Clearly, folks, in my opinion, these reports are not impartial. And when you start to understand the brainwashing that goes on behind them, there are some huge, huge issues that need to be addressed here. Because that's why I call, Transport Canada, the Transportation Safety Board, I refer to them as rail PICs, rail partners in crime. Because in my opinion, what's being done here is nothing short of criminal. It is a complete deception of the public, of rail families, of rail investors, trying to make it look as though the rail carriers were following the law when, in fact, they were not, and they were in serious violation of the Railway Safety Act, which is very much the overriding law in these matters. So the very key lesson here again is acts override regulations. And you need to understand that when you're reading an investigation report. And regulations override rules. Acts and regulations are both enforceable in courts. Rules, guidelines, standards are not. So that's absolutely key. And especially when they contradict each other. So the higher authority overrides the lower one. And in the Canadian rail industry, there's two main acts, the Railway Safety Act and the Canadian Transportation Act. The oversight of the Canadian Transportation Act, that's another huge problem, given again the Enabling Act for SOR 87-150, the Railway Employee Qualification Standards Regulation. That's overseen by the Canadian Transportation Agency, which again can be headed by rail executives like Jeffrey Hare of CP Rail. And remember, when John Baird left as former Minister of Transportation, when he left the Government of Canada, he went to the board of what is now CPKC. But both acts fall under the jurisdiction of Transport Canada, no matter who their agents are or what they may be saying or doing in their new regulations that they try and put out. Transport Canada is the overriding authority and governing body. So any shady stuff that's going on, yeah, definitely, we can consider going after those who did the actual shady work. But Transport Canada is certainly not without excuse. I mean, there is no justification whatsoever for the actions of Transport Canada in all of these matters, dating back at least to 2007, if not earlier. Okay, so as we conclude this video, in order to move forward and get into the brainwashing that goes on, key points to remember: acts override regulations, regulation override rules, and that's absolutely key, especially when they contradict each other. The higher authority overrides. And as we move forward and look into the brainwashing of rail families via quote unquote investigation reports, such as those provided by the Transportation Safety Board, I need you to keep in mind these three documents, because these are the three that are critical. First is the Railway Safety Act. That's the one on the left. And again, any changes to training programs or any formulation of rules must be approved by the Minister of Transportation before being implemented in the field. That's what the Act says. That's the ultimate law in the rail industry. The next one was the regulation, which is provided in Jason's accident report, where the key provisions there that you need to keep in mind are for SOR 87-150 is Section 5, that no rail carrier can allow an employee to work in a certain occupational category unless that person has qualified for that category. So a conductor trainee, by definition, has not qualified, and so they should never be allowed to work without supervision. And the other key point on Section 5 that is missing in the accident report for Jason Clooney is the fact that this law, point 5 here, this went into effect July 1st, 1990. That just mysteriously disappears as they then take information from the new proposed rules and try and slip that in, to make it look like it was in the works and not an actual law, when it clearly already was as of 1990. So we're going to get a lot more into the brainwashing as we move forward. And the other section for the regulation, which is important, is Section 19, where they make you believe in Jason's accident report, which is what's provided here. I give you page 9 of the Railway Investigation Report in the middle column on the bottom. In Jason's accident report, they don't tell you about the act, which says that any changes must first be approved for training programs. What they do is they first set you up with what's shown in the regulation, SOR 87-150, making you believe that within 90 days after any change is made to an employee training program, as required by Section 1 of the regulation, not the act, A railway company shall file with the committee a description of the change. So it makes it look like the only requirement there is after the fact, within 90 days, we must file a description of our change to our training programs. So that's what's provided in Jason's accident report. They removed the effective date of July 1st, 1990, that the law was already there, that you couldn't allow a trainee to work alone. And they removed everything tied to the act, saying that any changes to training programs must first be filed with Transport Canada and approved by the minister before those changes are implemented in the field. So what happens after this section on page 9 is they go into the report, in Jason's accident report, and they then tell you about the training program in place and the new changes, making it look like, okay, well, these new changes, as long as they were basically, filed, or the description was filed with Transport Canada within 90 days, they were fine. That's what they try and make it look like, all the while totally ignoring the provisions in the Railway Safety Act, which necessitated those changes be first filed with Transport Canada before field implementation. And then the last of the three documents I want you to keep in mind as we go through all of this brainwashing stuff coming up is the rules. The new document, which was created as a result of the Mackyard incident in 2007, and which was supposed to overhaul all the training programs, for frontline rail workers, according to that order issued by then Minister of Transportation John Baird. So that document, which the Railway Association of Canada came up with, and again, you can see it was a document by the Railway Association of Canada, by the logo here, and the, where it says Railway Association of Canada in the third column here, you can see that in the top document, it says Railway Association of Canada. And what's interesting though is at the bottom section in Jason's accident report, and this would have been on page 10, I believe, at the bottom of page 10, you see the reference there to the description of these rules in Jason's accident report. Now again, remember this very key change on the cover page, that these rules would not go into effect until the regulation is revoked or repealed. And the regulation was never repealed. SOR 87-150 is the regulation to this day. It was never repealed. And so these laws, the new rules never went into effect. So that begs the whole question, why would the Transportation Safety Board be discussing rules that were approved supposedly in June 2009 by the Governor and Council, but they never went into effect because the old regulation was never repealed? And again, it's a 2009 document. Why are you discussing it in a document that was written in 2014? Jason died in November of 2013. Why bring up rules that never went into effect years later? Because it's all part of the brainwashing that gets done when it comes to rail families and the general public. That's why I call it a total public scam. But if you look here at the bottom on the third column on the right, and you look at the reference in the footnote on page, I believe it's page 10, it's referred to as a Transport Canada document, not a Railway Association of Canada document, even though it's the Railway Association of Canada that wrote this document. Because it was then approved, I guess, by Transport Canada, we now call it a Transport Canada document, okay? And there's the reference number, TCO 0-102, rules respecting minimum qualification standards for railway employees. So again, why even bring up these bogus rules, this total public scam of a document, in a death investigation pertaining to the death of conductor trainee Jason Clooney years later, when these rules never went into effect? And the Transportation Safety Board absolutely knew that when they wrote their railway investigation garbage report pertaining to the death of conductor trainee Jason Clooney. Okay, so I'm going to stop this video here on acts, regulation, rules, guidelines, etc. What's the difference and why does it matter? I'm sure now that you can see it's critical that we all understand the law, especially given ignorance of the law is no defense in court. And so, whether or not you're a union rep, a rail family member, a rail investor, you need to understand these critical differences in order to then understand how you're being brainwashed in railway investigation reports, in occupational health and safety tribunal decisions, which can set very nasty precedents for the rail industry, as was done in the case of conductor trainee Jason Clooney. So, all critical issues. So, like, share, subscribe. Make sure you remain subscribed. And again, try to view these videos in the proper order that I put them out because they do build on one another. And on that, have a great day.